There's a 3 judges bench order by your lordship. Yes, where in fact, which is not produced in the petition. Lord, if your lordships kindly have a look at this. It's kindly, your lordships expressed before you start. Kindly. Lord, your lordships expressed a view. Please see, Lord, the order. Can I have a copy? Yeah, I'm just giving it. Lord, please see page 2. Page 2. Page 2. In fact, my Lord Justice Sanjay Bose is a party to it. They should have placed present petition stands allowed in terms of prayers A, so and so. Now, please read the last line, Lord. This court expects the state of Bihar is not a party before this court is this petition. As such, we make no comment as regards notification issued by the state of Bihar, legality of which have been challenged in this writ. But this court expects the state of Bihar shall take into account the judgment of this court delivered on 11th August. Now, on 11th August judgment states, you will not consider B.Ed candidates, only D.Ed candidates. Accordingly, though the exam was conducted for everybody, we have now declared in view of your lordship judgment the results for D.Ed candidates, and we have appointed over 1 lakh.
Yes. Petitioner said already gone.
Lord, before my petitioner starts, I'm not for the respondent. Lord, this matter was listed before Justice Gopana. Justice Gopana sent it here. Lord, there are several other MAs, 4 MA for clarification, which were listed, if I may pass the order, before a bench of Justice J.K. Maheshwari, and they passed the order that this be listed before the same bench, which had passed the 11th.
What are the MAs for?
MAs are for clarification. Now, what has happened is between 2018 and 2023, because your lordship set aside the notification in 2023, which is of 2018, your lordship said in the nothing about the middle. Now, in various states, various appointments of lakhs of teachers had been made, and various notifications issued, litigations also going on, processes completed, pending. So, what happens? Yes, 4, 5 MAs are defining the order.
See, essentially now question is whether those who are already appointed will be retained in service or they are working.
Also let that the process state of Bihar now that main primary issue is whether state of Bihar D.Ed or D.Ed candidates will be considered. That's all. Now state of Bihar pursuant to your lordship's order of 11th August and the
my learned friend is not pointing out that despite the judgment by your lordships, the state of Bihar during the pendency and despite the orders allowed these appointments to continue, the process to continue.
When were they appointed?
Yes, the appointment, the date of advertisement was 10th April and 30th of May of this year. Thereafter, the exam was conducted by them, allowed to be participated by us after the judgment.
No, were they appointed after the judgment or before the judgment?
After the judgment, but I'll tell your lordships.
Let's kindly consider this.
Lord, the exam notification.
19,000 persons had been appointed after the High Court judgment. High Court judgment was
my lords,
why are you?
I am raising.
Let us crystallize.
That's exactly.
Yes, I am raising three major arguments.
Yeah.
Yes,
I am exactly on Bihar only, but this is the point here.
Kindly
The
permit me.
judgment by which my lords held that it can only be D.Ed and not B.Ed had struck down the NCTE notification, which was Rajasthan High Court, which was on 25th 11/2021. That's the
on the ground
notification. Wait a minute. That's the pan-India notification because it was a institute notification. Now, once that notification was struck down, and my lords did not stay that striking down, no state could have gone and acted upon it, much less Rajasthan, which was the party to this particular matter of the judgment which is pronounced.
Right now we are considering.
Lord, please see the prayer. Please see the prayer. Prayer will indicate everything.
Bihar was the party, it had its own.
But where's the question of Rajasthan? Who is for Rajasthan?
Bihar was the party.
Lord, please see Bihar for prayer. Prayers in this.
My petition. Now let's finding
Petition is for Bihar.
Bihar, only Bihar.
Issue, because that issue came to be decided on 11th August 2023, and my lords will find in the judgment of this court one of the writ petitions before this court was arising out of state of Bihar.
That is why the order that has been read out.
That is being complied with today.
Yes.
Therefore, any appointment date approved
That cannot be done.
Yes.
Of the judgment.
Your Lordship have already
appointment can be
invalid that adjudication.
Not the examination notice. Examination.
What we are going to possibly do, post judgment, no appointment of B.Ed.
Very good. That's right. That's right.
Only judgment whether here we are concerned with post judgment.
That's right. That's right. Correct.
Your Lordship have already declared the advertisement invalid. You have to buy the order by your Lordship.
No.
Please listen.
Post judgment, here the prayers are for declaration of result. We cannot grant that in view of our judgment. Who are appointed,
That's a different thing altogether.
will examine when
The issue here.
The issue is in certain matters.
or even this.
No.
Or not then.
This is Bengal. We are dealing with Bihar now.
There are three states that what on the
We are not on that. We are right now confining our inquiry to
Bihar.
post judgment
In Bihar.
appointment.
Yes.
The prayers can't be granted for the simple reason that after this judgment, this would not survive.
Correct.
May I now, everybody else except the petitioner has argued the case.
Okay, now who are you? Yes.
The ramifications of the judgment of this honorable court are vast. The judgment has been rendered by this honorable court on the premise that the decision-making process resulting in the notification.
Right now we can't sit on appeal over.
No, Millet, I'm not
You ask for review.
I'm not seeking mere lordship.
These reliefs cannot
be ground. There are aspects, Millet, Millet, here. Legitimate expectation, Millet, is a doctrine. Kindly permit me to complete. Kindly permit me, Millet, to complete here.
Milord, one para kindly see for the same judgment, Milord. This advertisement has gone by.
I'll show the entire judgment.
Let's see the one side.
We are on this side or this side?
I am for the delayed condition. This side.
You are appointed. Why are you worried? State is
If you are appointed,
No, Milord. Your Lordship have declared the advertisement.
Why are you arguing for? If you are appointed.
Advertisement has gone. There is no
I
charge.
go into that issue. I am saying we are only complying with the judgment.
no, we are not saying. Only the petitioner will hear, no one else.
Let's kindly see.
State of BR, yes.
The advertisement was issued despite the judgment of the Honorable High Court of Judicature at Rajasthan, which was in appeal before your lordships. My rules entitle me for an appointment based on let me complete. Let me complete.
There is no.
Let me complete
You are
what I am
a review of this judgment.
No, I am not challenging the judgment. For the reason
What you are saying?
what I am saying is the process which started.
No, there can't be any protection.
Let's kindly consider this. My advertisement, I participated in the advertisement on the basis of the rules.
We'll dismiss the writ petition.
That's right.
Kindly permit me.
Why have you come to Supreme Court?
Only two aspects. I have filed additional documents.
Not your lordship. Record my statement that we have already complied with and declared the result.
Let me complete it.
Finish.
Yes.
I am not seeking your lordships to relook the judgment in the manner which amounts to sitting in appeal.
Don't put in the manner. You don't look at it at all.
Yes, in this case, I have raised a very...
1 minute.
1 minute. Let him.
Why are you arguing? Who are you for?
I am the intervener, my lord. We
are not permitting any intervener to argue.
No interventions.
This honorable court, being the apex court, having all the powers including Article 142 which I am invoking, in the peculiar facts and circumstances of the case, because right to education is a fundamental right created under Act of 2010. Simultaneously with that, so what I am saying is this,
Don't stretch it too far.
No, the vacancies, number of vacancies, a right to education, confers a fundamental right on the pupils who are deprived because of the posts not being filled up. There are more than 30,000 posts.
State is saying they fill all the
that the High Court of Judicature at Patna has said, after exhausting their appointment, if still the vacancies remain unfilled, the B.Ed persons can be given a chance. I take it further, on the basis of the policy decision, right in the year 2010, when this act was enacted, the national education policy was being formulated.
All that has no scope of argument.
For the reason, that policy matters, your lordships, do not interfere in the policy matters.
No,
the policy specifically says, the policy specifically says that slowly by the year 2030, TLED would be abolished. There will not be any course.
That is a judgment of this court. That TLED would not.
That judgment, I am trying to impress upon your lordships that judgment does not take into consideration or does not. It does not take into consideration the aspect which deserve to be taken in this writ petition.
No.
On the ground,
You apply for review, we can examine it.
Then kindly keep it pending.
No, you don't keep it pending.
Kindly keep it pending so that the review has been filed by those persons also, which is pending as of now.
We'll see when it comes.
Kindly consider this. Only 2 minutes more.
So far, you have none of them are on.
Kindly see the rules on the basis of which
we have struck down the notification.
What these are rules, with all due respect, the rules didn't fall for consideration. That's why I'm saying these was your lordship judgment. The rules in the state of Bihar mandate this as a criteria. We were eligible under the rules.
Only one petition. How many are changed?
The rules have not been set aside. The rules are still enforced. The state says that it will implement your lordship.
I have challenged the rules. I have challenged the rule, and
That's
not
okay.
part of the.
That's what I'm saying. Today,
Not a judgment of this court. The judgment can't be confronted with the rules of this case. The judgment.
Anyway, let's see.
Kindly have it, all the cases on Friday, then along with those applications.
The rules say as per NCT. Once you have struggled with the NCT notification, what is that? Here,
kindly see the rules for a minute. For a minute,
On page 433, 434. Page 433,
On 11th August 2023.
Before that, I want to see one.
No.
I to see there's.
No, we are not permitting.
on the writ clause, there are no interveners.
11th August 2023.
Kindly consider,
Coordinate bench.
kindly consider permitting me to withdraw it with liberty to fight me.
The order is
One of us.
Please
The
don't.
party only. Of which one of us is a party. You had delivered.
May I withdraw it, please? May I withdraw it, please, with liberty, so that
Withdraw.
But again, it will be reopened elsewhere. I tell your lordship,
it is followed.
this matter came up
It is following from your lordship. I am not saying this.
Conditional withdrawal.
It is falling from your lordships itself, ladies, that I can seek review of that judgment which is coming.
No, that's, we are not.
Lordship,
Now the
your lordships, please, others also can file review.
If we dismiss we are not here to advise you.
No, I am not saying that. I am not saying
The way
saying
we
that.
dismiss made
The remedy of review minutes may not be taken away. The remedy of review minutes which is available to me in law minutes under Article 137.
Not saying anything whether you can file it or not.
My lords, just keep
delivered a judgment striking down the notification.
Let's then all like minutes I'll withdraw simpliciter minutes, whatever.
What's happening here is that under different names, there are many
Advocate appearing for the
one
petitioner
here, then another somebody else will file the whole.
submits.
And you won't have an offer.
Your Lordship may say after arguing for a while, because I'll tell you, Your Lordship, why. It came up before Justice Bopanna's bench, and I pointed out this order. That is how it has been placed here.
After arguing for a while, learned counsel for the petitioner submits that his clients would not like to proceed with this writ petition. The writ petition is hence dismissed as withdrawn.
Obliged, grateful.
And application also
Dismiss all applications.
All convicted applications
disposed of according to
shall stand disposed of in view of this.
time reason.
Obliged.
That's